And I want to welcome everyone to the second portion of our introduction to land records in North Carolina. In the previous segment that we recorded a couple of months ago, we discussed the basics. We discussed the land grant process, who was the sovereign authority over land in North Carolina originally, and how it was transmitted to the first private owners, and also how it was conveyed through deeds, what the background of land ownership was in Europe, and how to access deed records and to interpret the portions of various deeds that you find. And now we're going to move on to another category of records regarding land that are a little bit more difficult to use because they require some specialized knowledge, but can be so important to tracing the chain of title and to finding out details about the owners and their families. There's those who thought that deeds, grants, and tax lists are the only source of information touching upon land ownership. I have very good news. By far the richest information about the land, and better still its occupants, can come from loose papers and court dockets related to civil cases at law. Land was the reason most people came to America in the colonial period. For common folks in Europe, the ability to own and pass land along to their heirs was exceedingly rare. The ownership of land was often the difference between abject poverty and dependence on the one hand, and a stable, adequate living independent of one's social superiors on the other. It's no wonder that our grandfathers and mothers were so adamant about protecting their interests at law. Land cases were handled at all levels of court jurisdiction. They usually began in the local county or superior court, and then they could be appealed into the higher courts, which varied according to the time period. Court structures are not static. They change over time. Different courts appear. Old courts are diminished or fall away. There is a short table of these in a handout that I can provide you, tracing how the courts evolved over time. So be sure to write to me at larry.cates, C-A-T-E-S, at highpointnc.gov if you want the associated handout that goes with this presentation. The loose court papers, which can be used alongside the dockets for a complete sense of the course of litigation, vary in their completeness from one county to another, from one court to another, from one period of time to another. But whatever the degree of completeness, they will fill in some of the gaps and offer new avenues of inquiry. Now, I realize that legalese can weary the soul, so I want to try to keep the technicalities to a minimum today. So I am definitely going to give you a broad sense of the different types of actions that are out there, but I don't want to get mired in the legal minutiae. My primary goal is to give you a sense of the breadth and the richness of the material that is available so that you will get excited about the possibilities for your research. Hopefully that will motivate you to learn a little more about the law in order to access the riches that court records hold. It's really not that complicated, quite honestly. Remember that the lawyers of the 19th century and before were rarely educated in law schools. The law they understood was rudimentary because they were mainly self-taught men who apprenticed with other attorneys. Likewise, the men who were justices of the peace were often limited in their education, certainly more so than the average citizen today. And yet, they learned enough law to administer the local courts and handle all manner of simple legal actions. So what I'm saying, quite simply, is if they can do it, so can you. So just to whet your appetite for the kind of record that you might find and the depth of information that you might mine out of these sources, I'm going to give you a particularly interesting one that I located in my family. The man pictured here is my great-great-great-great-grandfather, Adam Moser of Randolph County, North Carolina, and he figures somewhat in this tale. This is drawn from a case that I found called Adam Moser versus Solomon Brewer, George Wilson, and Isaac Wilson from 1848, and is taken from civil action papers in Randolph County. In this case, George Wilson, about 70 years of age, owned a small tract of land on Solomon's branch, about 200 acres. He was aging, and he had a sore leg from a recent fall, so he decided to distribute his property. He had already made out deeds for portions of that land to some of his children, including Thomas and William Wilson. He did not record these deeds, however, which was possible at the time. You did not necessarily have to record a deed to make it legal. You did have to deliver it to the party that was to receive the land for it to be in force. The last deed was for 37 acres, the home tract where his house was located, which he made over to his son Isaac in 1832 or 1833. But again, that deed was also unrecorded in deed books. Isaac Wilson subsequently got into trouble for debt and decided to move west. He made over his property to his brother-in-law, Adam Moser, in 1844. They had both, by the way, married into the Wrightsman family. A number of the Wilsons still lived on the property, including George's sons Thomas and William Wilson, a daughter named Sally, who apparently had a child out of wedlock, and a daughter named Polly, or Mary Wilson, who was debilitated in some way, according to Thomas Wilson. I think she had trouble walking. Other family members either gave testimony or were mentioned in the documents associated with this case, including a daughter named Margaret Pugh, another son named James Wilson, grandsons Solomon Brewer, Albany W. Brewer, and Jesse Wilson, the son of James Wilson. George Wilson then decided to make a deed for that same 37 acres that he had to Isaac to his grandson Solomon Brewer. Among those witnessing this deed were Robert Wilson and the two Brewer grandsons. He claimed that the first deed to Isaac Wilson was of no effect, that he had merely let him use the land and had not truly conveyed it to him, even though a document existed. Other incidentals that we learn in the testimony associated with this case, all written down. William D. Reese mentioned a trip by Thomas Wilson's home in March of 1847 on his way to his uncle Joseph A. Allred's home. Polly Scotton was very intimate with the Wilson family as she gave testimony about these matters on several occasions. Joseph L. Reese was asked to give information about the character of Polly, Sarah, and Martha Wilson. Now, this case illustrates the importance of delivery to the legality of a conveyance and the wonderful range of information that in an optimal situation might arise from a single legal issue. Almost everything that I told you previously came from the documents associated with this case. Just think about all the important family information that was there and stuff about neighbors, just incidentally drawn into the case because they had some knowledge of it. They talk about their own family relationships a little bit. Note here that there would be no will or estate record, most likely for this George Wilson, and the deeds in question were not recorded. Then as today, the courts were the last recourse in establishing property rights, satisfying obligations through the liquidation of land, and settling disputes between rival claimants. So the question here was, did Isaac Wilson really own the land, or did the Brewer grandson? And if Isaac Wilson owned the land, then my ancestor Adam Moser should have received it because he conveyed it before he moved to Tennessee to his brother-in-law. So let's pause for a minute and think about what kinds of sources we can use for court cases that came before local or higher courts about land records, land ownership, disputes about where boundaries were, etc. What are the sources that you can go to find this information, and where are they? Well, first of all, most of our old records in North Carolina from the 19th century should have been forwarded to the state archives. So that's where you're going to find most of this information. Not that much of it will be found online, although some things will be, and I particularly point you to that excellent website, Family Search, where you can get a free account and go in through the catalog by locale, putting in the country, the state, the county that you're interested in, find those land records and those court records that have been microfilmed and then digitized by Family Search. That could help you, but a lot of this material does not exist in digital form. It will have to be viewed in its original form at the state archives. One of the basic sources for any court proceedings are the minute dockets of the court and other related dockets like recognizance dockets, summons, execution dockets, equity and rolling dockets. There are all kinds of different dockets that clerks of court kept to provide access to what cases had been heard when. Minute dockets are our most familiar one because they really detail precisely what courts did on every day that they met in order of what was considered. And they provide a window into when a case would have been heard, over how many terms of court it would have been heard. So if you look first in a minute docket or another form of docket, like a civil docket or a trial docket, it can show you where to look in the more detailed sources like the papers, what years to look for, those records that relate to a particular case that interests you. So that's mainly what they're used for. Also in the minute docket, you're going to find the decision of the court eventually at the term where the decision is reached. It may be very brief, and that's just typical of dockets. They're brief information that lead you to other things. You can use them kind of like an index, but still, without looking at the papers, you're not going to get full information, and you're going to miss a lot of incidental items about your family that are in cases regarding their neighbors, for example, that they happen to get drawn into. Then you have the papers themselves, civil action papers, and civil actions concerning land, and sometimes another one called ejectments. Those are all loose papers associated with various cases that came up before the court, including those that dealt with land. Sometimes these are called dismissed court papers or dismissed judgment rolls in other jurisdictions, but they're basically just files of information related to particular cases, and sometimes archivists have very kindly grouped things about the same case within the same year together. At the North Carolina State Archives, there are reams, boxes and boxes full of civil action papers from many counties. Now, there are some counties where they have not been kept very carefully because they're very voluminous records, and think about how many of them piled up over the years as each court term sat and disposed of business. So they became a burden for many county clerks, and some of them threw them out over time, and we don't have them anymore. But a great many counties have large volumes of records that do survive. Guilford County, where I currently work, is on the one side very limited in the surviving loose papers that are there. But neighboring Randolph and Davidson County, their papers are very complete. Their civil action papers are very voluminous. And in fact, they have been digitized for almost all the counties in North Carolina. The civil action papers, which are the ones most likely to deal with land, have been digitized and placed there where you can Access them freely from the comfort of your own home. Once you know that a case exists, you look through the years involved for the individual papers that might be there. Now, what's going to be in those papers? Well, it includes things like summonses for the parties to the case and witnesses who were called, executions on property to satisfy the judgments of the court or to pay costs, bills of cost, witness tickets, appearance, prosecution, and appeals bonds, petitions and answers, sometimes written down, judgments of the court, affidavits and depositions when written testimony had to be taken. And those are the very best sorts of records, giving you all the kinds of detail that I just shared with that Wilson case. Documents entered into evidence like legal documents, personal letters, promissory notes. There is no transcription to be found of what happened in court until the modern era when dictaphones were available. But if petitions, answers, and depositions survive, you get a very good picture of the issue in the case and the personalities and the viewpoints of the parties, as in the example that I provided. These papers at the North Carolina State Archives have been divided into a special section sometimes that are particularly concerned with land, the civil actions concerning with land. That's a separate category within that segment of civil action papers that you should definitely look through. But don't presume that the papers associated with a particular land-related case that you're interested in are there. Many of those will still be in civil action papers in the general run of civil action papers. And you'll have to go back through maybe 2 different sets of papers for a given year, one under actions concerning land and one under civil action papers, once you know that that case exists from the dockets. Ejectments are a very formal process of dispute over title to land. Who really owns the land? And these often have their own category in which they are filed at the state archives, so look for them. The complaint in these cases it adopts highly formalized language that is difficult to penetrate through, but the other papers will be very, very easy to follow, probably. There are some disputes about land in estate files associated with the deceased people who previously owned the land among their heirs about how it should be partitioned out and who has title to it and who doesn't. Does one party need to get a little bit more of the property because they absorb some costs related to caring for the deceased person, etc.? Where did the land descend from and under what limitations was it placed by prior owners in how it should descend? All those kinds of things might be found in estate files rather than civil action papers or civil action papers concerning land or ejectments. There are special proceedings dockets and rolls, particularly important for boundary settlements in the post-1868 period, allotment of dower and easements when parts of land needed to be set aside for other people to use, just for practical considerations or because of prior legal arrangements and agreements. There is the Lands, Estates, Boundaries, and Surveys series in Treasurers and Comptrollers papers on the state level for material related to confiscated estates from the Revolutionary period. Dr. Pruitt, Albert Bruce Pruitt, has abstracted almost everything related to land confiscation post-Revolutionary War. But you can also look at the minutes and papers of the district superior courts that existed at the time the confiscations took place because they had ultimate jurisdiction over how that process played out. There are Secretary of State papers in North Carolina at the state level for colonial petitions for resurvey of land grants, petitions for suspension of warrants, and caveats to land grants. We talked a little bit about the land grant process in the prior presentation, but there's also a dispute process that could happen at the state level before the grant or just after the grant was issued, because there was a concern always that there could be overlap in grants, that boundaries could be fuzzy, that other people might have prior entitlement to apply for the grant, and a lot of that would be worked out in the early period and not be handled in the local courts, but rather at the state Secretary of State's level, where the grants originated. He was in control. That officer of the Council of State was in control of how the land grant process played out. And don't forget plat or map books, mostly in the 20th century, because plats can be generated related to disputes of where boundaries are. And sometimes you'll even see plats on loose sheets of paper in the civil action papers themselves associated with court cases about land. So why all this land litigation? Well, we know that the parties were very interested in defending, maintaining their rights to land because of the value of land and keeping people independent, providing them with their sustenance. But why were all the disputes happening? What situations, what circumstances made it very likely for land to come into dispute between parties? Well, in these eastern seaboard states, we have a system of land measurement that differs from the western states. A lot of the western federal land states used a very precise grid system to lay out land to people who applied for grants from the federal government. Here in North Carolina, our land ownership, our parceling out of the land to individuals started happening in the colonial period, and it didn't use a very neat and tidy system of laying out tracts. Instead, it used a messy system, a meets and bounds system of surveying, following various trees, various waterways, particular landmarks, which could easily disappear or be moved or even shift over time, as in the case of a creek. Or what if that tree that's a corner boundary, dies, is cut down? Grid systems based on fixed meridian and quadrilateral section surveying were much more stable than the system that we used here. And those ambiguous boundary markers could lead to litigation further down the road, and often did. The lack of requirement to record deeds, obscuring the title of the chain of title to a property, was not changed until the Connor Pure Race Registration Ordinance of 1885 in North Carolina. After that, anyone who got to the courthouse first with documentation regarding owning a parcel of land was given priority, theoretically, in maintaining that title. So if you had just been passing along all the old deeds back to the grant to a new owner when they purchased that property, and you had not recorded all those deeds, that new owner after 1885 is suddenly going to be very interested in recording all of the old deeds in the chain back to the original grant to make sure that their title is clear under the new Connor Act. But before that, it was very, very common to just hang on to your deeds in your home and not make a recorded copy at the county courthouse because it involved a fee. It was expensive to do, for people who had very limited means. So a lot of people just neglected doing it, as we heard about in the Wilson case. And when you don't have public copies of your chain of title, and maybe something happens to your own personal copies of the documents, what are you going to do then? Somebody could easily come in and make claims that you would compete with yours and which you couldn't easily overturn. The complexity of the land grant process led to problems. It relied on individuals to enter into mutually exclusive tracts and it relied upon surveyors to detect overlapping surveys before they were finalized into grants. Overlapping surveys often coexisted for years until a change in ownership occurred relative to one or the other of the tracts. Guardianship or trusteeships meant to protect the landed interests of vulnerable individuals like minors, incompetents, and the feeble and elderly or disabled, gave great occasion for abuse. Trusteeships and deeds of trust for the securing of debts could also lead to legal complications, as in this example from Guilford County illustrates. But before I go on to that Guilford County example regarding guardianships and trusteeships, this just shows you how the Connor Pure Race Registration Ordinance changed things. This is an original deed regarding the Welker family in Guilford County. The deed was actually executed in 1813, but it was not recorded ultimately in the county deed books until 1885. And because I was researching this family based on when it existed, when the family members lived here in Guilford County, I at first did not find this deed. I did not look down the grantor-grantee index past 1885 because I knew nothing about this legal change that prompted a lot of people to record deeds. And this particular deed gave me all the heirs of the original George Welker of Guilford County, and identified a son I didn't know about at all who went west. So with regard to guardianships or trusteeships that could go wrong, I'll give you an example from some of the surviving loose papers regarding land that we have here in Guilford County. In 1854, we learned from a case in Guilford County civil actions concerning land, Jehu Parsons secured multiple debts by delivering over to H. Lindsay as trustee a 50-acre tract on Deep River. Apparently, Parsons managed to pay off all but one of the debts that he owed to B.W. Stevenson. Stevenson endorsed the note over to other parties before collecting on it, and through a long chain of ownership, that note finally came to rest in John A. Gilmer's possession. People don't often realize, but folks signed a lot of IOUs back in the day because currency was hard to come by, and they used these IOUs as money. So one person who was owed a debt might sign the note over to someone else for that person to collect. And that was a way of that person paying their own obligations to someone else by giving them a debt that they owed, that was owed to them. Meanwhile, Parsons moved away to Kansas City, Missouri, via Indiana and Kansas, the court records tell us. Jehu Parsons reportedly made an agreement with his brother-in-law, B.Y. Clark, in Guilford County, through a letter written to Clark by his wife Asenath Parsons, proposing that Clark was to have the land if he would pay off the remaining debt to Gilmer, plus interest, and remit the remainder of $250 to Parsons after 2 years. The only evidence of this agreement between the brothers-in-law was the letter written in Asenath's hand and not signed by her husband, Jehu Parsons. Clark did pay off the debt to Gilmer and provided evidence that he had done so to the trustee on the deed that Jehu Parsons signed, that deed of trust, which is kind of like a mortgage, a debt instrument. It doesn't affect the land unless the debt is not paid. So Clark did pay off the debt that his brother-in-law owed. He then demanded a deed from Lindsay because he wanted to sell the tract to Elwood Morgan. Lindsay would not execute one until the court assured him that B.Y. Clark now held good title in the land because all Clark had was that letter that was written by his sister and or his sister-in-law, one or the other. After all, the only thing he had to go on was that letter, and a copy of the letter from Asenath Parsons was attached as an exhibit to the court case. So in that little letter, which is also a personal letter, it's not just a business letter, we learn about the migration of Parsons and his relationship to Clark. We also learn that a person named Gilbert was leasing the land in the interval while all this was being settled, which reminds us that apart from all the legal instruments that we have conveying ownership, there are a whole other class of people who are leasing land, who are living on land that they don't own. Sometimes their names come up too, and that's good to know for people who have poor ancestors. Another circumstance that could lead to a lot of land litigation, and did, was illiteracy of the parties. Naturally, people who could not read and write, and that was rather common in the 19th century, were vulnerable to the fraud perpetrated on them by more educated associates. And I'll give you another example that comes from a legal case, the case of James Moore versus Peter Self and John Hollowell, which is also in the civil actions concerning land papers were associated with Guilford County in North Carolina. James Moore brought suit in 1835 against his nephew Peter Self to recover his land in Chatham County when he was about 88 or 89 years old. In this petition, he stated that he and Peter Self's father had married sisters in Westmoreland County, Virginia. Now, he says this in his court filing, so this is information you'd not necessarily expect to find here. His origins are revealed, and the origins of the other family, the Self family and the Moore family. Shortly thereafter, he moved to North Carolina, but learned that his sister-in-law Self had become a widow in Virginia with 3 small children. He came back, therefore, and moved her and her family to North Carolina, where he acted as a surrogate father to his nieces and nephews. Peter Self and he had always been particularly close, he says. But then, in 1828, due to some failed lawsuits over land, Mr. Moore, James Moore, the nephew, the uncle, became liable to pay costs to the court. And when these suits were ongoing, Peter Self proposed to help his uncle out and represent his interests in the case. He proposed that his uncle grant him a power of attorney to do so and settle with his adversaries at law. Moore executed the so-called power of attorney, but he didn't realize, because he could not read, that it was actually a deed of trust for all of his land. The land was then occupied by James Moore and his son Samuel and Samuel's family. Self actually had to take up residence in a slave cabin on the land when he was barred entry to the main house. Later he gained access to the house and threatened his cousin Samuel Moore, so that Samuel moved to the slave cabin with his family to avoid a fight. A daughter-in-law, the wife of James Moore's other son, Priestley Moore, would come to tend to the old fellow's needs daily until she found that she could no longer make the trip conveniently, and so asked her father-in-law to leave the property and live with her temporarily. Moore lived there until Priestley's family moved west, when he moved in with his son-in-law Richard Williams. He and his whole family were ignorant and poor people, he said, who couldn't easily find their way out of this tangle. Just note the incredible genealogical detail that is contained in this man's declaration to the court, his complaint. He was seeking remedy under the law of equity, which is a way for people to escape from the technicalities of the law when justice and fairness are not being served by adhering to it. In the post-revolutionary period, the activities of speculators, which led to many land fraud investigations and unfortunately to the dispossession of many soldiers from their bounty rights, also resulted in litigation. In this same period, the loss of loyalist property under the Confiscation Acts became a source of contention over title. Another aspect that led to mix-ups over land ownership was the limited nature of land ownership, which made it something short of absolute. One aspect of this is limited use by non-owners, when neighbors hunted and harvested timber across tract boundaries, and when cattle, horses, sheep, and swine ranged freely, leading to disputes about trespass, literal trespass on land, and damages that resulted from it. Poor people without land of their own were particularly likely to trespass. There were all kinds of cases in which poor folks were caught hunting or fishing or collecting timber on property belonging to someone else. This was particularly complicated when the owner had not posted his property properly, or when he had allowed individuals to squat on his land and live there as tenants or sharecroppers. Where did their rights begin and his end? All this had to be determined at law. Free-range stock laws required that crops and not stock should be fenced in until 1879. Most people were letting a lot of their stock roam freely across properties that did not belong to them. But it was up to people protecting their growing crops to fence them in up until 1879, when all of that changed. After that, every individual county could determine what their stock laws would be, requiring fencing of stock within their jurisdiction. In 1885, the people of Guilford County voted to take advantage of the opportunity to do away with the old stock laws and to require fencing. But neighboring Randolph County still allowed free range for livestock and required fencing for crops. That meant that a fence had to be built across the southern courses of Guilford County to keep out Randolph County stock. I call that the Great Wall of Guilford. Contracts were signed for builders of various lengths of the fence. Also, the cutting of public roads and bridges across private land, which allowed the removal of earth and poles and other necessary timber from adjacent areas, and also created disputes about where roads should run across land, or whether the road should be diverted in one direction or another because of the landowner's requirements and needs. An example of this is a document that's filed in Randolph County Civil Action Papers, where Anderson Needham is warning his neighbor John Gatlin and his boys, and it's dated the 21st day of July, 1840. I have and do forbid of you hunting up above me. You have been hunting up above me on my land and father's, and I shall forewarn before witness one and all of you. For you've been in the habit of hunting, fetching in others to hunting with you, and now you must keep off, you and your dogs, and if you don't, I shall kill your dogs, just as sure as I catch them on said lands, and you may take it for granted. So I heard you was going to take a hunt up in here before long. I shall watch for you and all your inhabitants. I have friends plenty to back me out, and you have been in the habit of skulking over the woods wherever you pleased, and we intend to put a stop to your frolics, and the sooner the better, for rogues shall not be roving over our woods, as they have, for there will be watch keep out for all such. And so you may hunt on your own claims, if you have any, or get the consent of others before you run yourselves into measures which you may meet with some difficulties. So take heed from this. What colorful language. A document actually filed in court records of one landowner warning out other people from hunting without authorization. Other examples of situations leading to land conflicts were rights of ownership, or rights of use, rather, under contract, lease, or dower, distinct from outright land ownership itself, like rights of way, easements, or lease terms, water, timber, and mineral rights, fishing rights, or dower rights, which only extended for the life or widowhood of the woman in most cases. Otherwise legitimate use of land affecting neighbors could lead to litigation, as in draining lowlands, burning woods, building structures or fences near boundaries, obstruction or turning of roadways, or construction of dams for mills or ponds which would flood over someone's land that was lying adjacent. That often required court approval, notice, and or compensation to other landowners. Docking of entails could lead to litigation in the colonial period. Up until 1784, it was possible for a testator to lock his heirs, usually the eldest son in that line of descent, into permanent ownership of a tract by bequeathing it or deeding it in fee tail rather than fee simple. And that would just mean I leave this land in a document to John, my eldest son, and his eldest male heirs forever. And that would lock the current owner and his heirs into possessing that land literally forever, unless the entail was docked officially by a court or the General Assembly. The owner had to show cause for selling his land that he had received under entail and might have to entail another parcel in compensation, unless it was a very small and inconsiderable tract under the value of 50 pounds, according to a 1749 law. The revolutionary spirit kind of did away with entails, which was an old world aristocratic bit of regulation designed to keep land in landed gentry families and aristocratic families and avoid wastrel heirs from destroying land ownership for an entire family. And then there are finally adverse possession laws that led to litigation. 20 years of occupation and use by a party without title to property and without protest from the person who actually held the title could affect a transfer of land ownership. This was meant to apply to abandoned lands in the colonial period, principally that were received under land grant. But the law has persisted on the books to the present day, and it has resulted in some novel legal strategies to acquire property. So litigiousness it has a bad name, certainly today, but the fact that our ancestors were so willing to sue one another is good news for us. More litigation means more information. But courts also dealt with other land-related issues, and in the minutes you'll find references to things that don't have anything to do with litigation per se. But still, the local county court was not just a legal body, not just a judicial body that involved trials of this case or that case. It was also an administrative body before the county commissioners system started. It actually administered day-to-day governance of the county involved, including a lot of things that had to do with land. And one example is processioning, which is an order by the court, usually at the request of a landowner, for processioners, people appointed in various districts of the county, and affected parties to walk off the boundaries of specific properties and return a report. Any dispute would be noted in the report and returned to the court for a decision. In North Carolina, this usually happens specific to a particular dispute, but it could also just arise when a person wanted to reaffirm a particular boundary on their property. You sometimes will find among the loose papers a notice of 10 days to neighbors of the day that the survey would take place so that they would be able to appear and defend their own interests in the process. If the affected neighbor did not appear, a panel of commissioners or a jury of the community might be asked to accompany the cooperating party and the processioners and decide the dispute. 2 uncontested processionings of a property by the same owner would solidify that person's claim and make it very difficult to unseat him in the future. Now in Virginia, this system was done regularly, not to resolve particular problems about land boundaries, but on a regular basis for all properties, every 4 years in fact, and was overseen by the vestry, the parish vestry. North Carolina didn't have parishes on the same level that Virginia did. Virginia's where Anglican church establishment was very strong, and North Carolina's was very weak. This is a function that would happen in England in the old days as well, and that's where they got this custom from. Everybody in the community or certain people within certain areas walking all the boundaries for all the land tracts and making sure that all of the boundary stones and markers, the trees, etc., were still there, or defining new ones to replace old ones. This was just to avoid problems before they happened. Then we have executions against land levied by the court. So in civil or criminal issues, losers in a case were required to pay court costs, fines, and amounts recovered by plaintiffs. In an era short on hard currency, personal property sales, in the absence of enslaved people, often would not satisfy the amounts levied in these cases on losing parties. This meant surrendering land for sale by the sheriff, and it was often sold well below its actual value. An execution often begins, "To the sheriff of the county of X, greeting. You are hereby commanded that of the goods, chattels, lands, and tenements of John Jones, if to be found in your county or bailiwick, you cause to be made the sum of whatever, $50, 50 pounds, which lately in our court of pleas and court of sessions held for the county of X at the courthouse in blank on whatever date, were adjudged in the suit wherein so-and-so is plaintiff and this person is defendant." Now, certain personal items were exempt from execution after an individual had declared himself insolvent. Tools or minimal amounts of livestock, bed and furnishings, and this could also be true of the homesteads, which were more common after 1868. The first legislation occurred in 1858, including registered personal property up to $500 and land and home up to $1,000. You'll also find records of probate of title deeds and deeds of trust, usually at the end of every term of court minutes. Either the grantor had to appear on a deed and admit that the conveyance occurred, which is called acknowledgement, or one of the subscribing witnesses, 2 or more in number, came into court and proved the deed. That person who proved the deed, the witness, is called the jurat. J-U-R for short, often. Usually they appear at or near the end of the minutes of the court term. In the absence of the grantor or surviving witnesses, an individual could swear to the handwriting of the grantor or one of the witnesses, and that could help establish the time of death of one of the parties to the deed or the witnesses. Usually these just duplicate what appears in the deed books. But what if there are gaps in your deed record, missing deed books, as occurs in many places? They make a nice substitute. And there are sometimes items appearing in these lists of probate of deeds that are not indexed or even were never actually recorded in the deed books, even though they were ordered to be recorded, because they were overlooked or failed to be transcribed, or in the case of bills of sale for personal property, were not required to be included in the general index. Like conveyances of enslaved people counts as personal property, not real estate. And in North Carolina and a lot of other places in the South, those bills of sale that were recorded in deed books did not have to be put into the grantor-grantee indexes, and often they were not. So the lists of probates of deeds and deeds of trust and bills of sale at the end of court minute sessions is really, really helpful sometimes. Also here you'll find declarations of insolvents presented by individual tax collectors. May show acreage and polls of individuals who could not pay their taxes because taxes were levied on both individuals and land for much of our history. Likewise, lists of land sold for taxes with former owners find their way into court minutes. In the absence of tax lists for that date, these provide a record for people in financial distress. And there are petitions for licenses related to land use, for instance, turning the public road in a different direction across a particular tract of land, or establishing a mill or ordinary, or damming a stream. There are petitions for dower or land division, mostly in estate papers, but not always, and they can be in the court minutes. They should not, however, be considered to be legal cases. I often have people coming to me saying, "Oh, the heirs to my grandfather sued my grandmother." Well, no, that is just it looks that way because it's A versus B, C, D, and E, or the vice versa. But this is a formal procedure. It's merely pro forma. It doesn't mean they were actually suing. They were just going through the legal process to provide the widow with her dower. Orders to allow individual declarations of taxable property and avoidance of double taxation, which may list assessed value, acreage, poles, and other taxable property owed by individuals. All these little tidbits can be found often in court minutes and have little to do with litigation per se. And here's an example of an execution on land issued by a court to satisfy a debt. This involves my ancestor Robert Cheek Sr. and explains how his land disappeared without there ever being any deed recorded about how it was disposed of. I found it among civil action papers in the county of Orange. And this is a list of acknowledgments and proving of various deeds in the court minutes. Thinking this is probably from Guilford County. It appears to be so. And shows you who the witness was who proved the deed, who the grantor and grantee were, and the amount of land. And in the absence of other records, sometimes this can show you that land was passed from one person to another. You can also find records of transfer of ownership of enslaved people in this list very frequently. Almost always, not always, but most of the time at the end of each session of court minutes. And here we have a list of insolvents who could not pay their taxes or who had left the area. And it tells us which kind each person is. Taxes were taken every single year. So these lists of people, for instance, William Kirkland had gone, Samuel Edwards had gone. Some of these people might have died. This will all be noted in the insolvents list. Very helpful information regarding land. And here we have a miscellaneous little snippet about land, which is basically just describing an error that was made in how land was described in a legal document, and it needed to be corrected in the grant. So a petition was made to the court, and the court ordered that alteration be made. So when it comes to actual disputation over land, there are specific kinds of disputes that occur under different circumstances in different categories of records, often filed separately from one another. So let's talk about disputes and what kinds of disputes exist. First of all, caveats. During the 3-month waiting period between the entry and the warrant involved in a land grant, caveats could stop the process at the county level. If the 3-month waiting period was exceeded, only a petition to the governor could do so up to the point where he signed the grant. The governor halted the process by a letter to the Secretary of State. The Secretary of State then notified the justices of the peace in the locality, who conducted the trial on the land by a jury with surveyor at hand. General verdicts awarded the entire tract to one party, and special verdicts required a division of the land between two different parties. Opportunity existed for appeals, and then results were conveyed to the Secretary of State's office, who issued the final grant or grants. The result is often only found by looking at the actual land grants awarded. There are references to these caveats in Secretary of State papers, though they may not be exceptionally informative. However, court proceedings related to caveats are sometimes found among the loose papers of the court in which they were adjudicated. Boundary disputes usually arose many years after the original conflicting surveys, unlike the caveats, and they were made or may often result from altered landmarks. Often they involve one or two parties, several removes down the title chain from where the original conflict originated. Sometimes they include testimony from older people, familiar with the original surveys who give their ages, because that's an important part of their credibility, that they were old enough to remember some of these details about land ownership. Trials on the land with the jury actually present to look at where the markers were and where the disputed areas were sometimes took place in conjunction with a resurvey or processioning. Notification was given to the affected party, and that was required of the plaintiff. The defendant was to be present, and if he delayed the action through non-appearance, a jury of the neighbors might be asked to stand in for his interests. Plats of the tracts usually created with graphic presentation of the overlap. Those usually occur in these cases, and these issues might be settled by a court decision or an arbitration of commissioners who are appointed specially by the court to arbitrate between the parties. Ejectments are boundary disputes, or they could be absolute disputes over absolute title to the property. They could be settled by a simple survey or arbitration, and they really are just one type of dispute that might be settled by an ejectment. Ejectment is a formal action at law in which the plaintiff attempts to expel the present occupant from a piece of land, from his possession of that land, by contesting his title to it. And it employs a legal fiction reaching back into the common law, which tenants of the rival parties are said to be the actual contestants over the tract and stand in lieu of the actual claimants. And they're given weird little names like John Den and Richard Finn, these so-called tenants, or Doe and Roe, or good title and bad title, or hold fast versus thrust out. In the bill of complaint, like an indictment in a criminal case, you will find these names, and they're not real people. They are just legal fictions that stand in for the real parties who are contesting the land. You have to look elsewhere in the documents for the names of those parties, but they are there. That's just a weird little wrinkle at law arising out of common law practice in England many years hence. And the names can get really inventive. Like sometimes in a particular case, I've actually seen Thomas Jefferson versus Napoleon Bonaparte used as the contesting parties or tenants of the parties who were contesting the ownership of the land. Now, what led to ejectments typically? Well, errors in surveying, errors in the drafting of deeds, particularly as regarded the courses. The present or a prior occupant in the title had a defective entitlement to the land that cannot be sustained under the law. A dispute over the terms of a lease or deed of trust and their fulfillment could be at issue. It could be whether or not valuable consideration actually passed between the parties in a deed. It could be because the grantor, in somewhere up the chain of title, actually delivered the document. He didn't deliver the document to the grantee, or maybe, locked it away. A deed is not in force until the person who's receiving the land has it in their possession. Whether or not the heirs of a landholder had acquired his debts, and whether the land he had owned, now vested in his heirs, was liable to pay those debts. Whether or not the person granting title in a tract to another was unduly pressured or had insufficient mental capacity. Competing hereditary claims in land, as in whether land is properly inherited from the father or the mother or the grandparent, and under what restrictions. Eviction of squatters could be involved in an ejectment. Competing or overlapping land surveys under state or colonial grant discovered well after the grants were issued. Informal and unregistered land conveyances, like the ones we've talked about earlier with the Wilson family. Adverse possession rights, where somebody's occupied land that's been allegedly abandoned, but the old owner comes back and disputes it. Or the same land sold by two different individuals, or by the same individual to two different other people. And we've seen an example of that before, but we'll see more. Now, here is an example of an ejectment taken from Randolph County records related to the warranty clause in a deed, which we talked about last time in our previous discussion. And it comes from 1846. It's an excellent example of genealogical information in local color arising from a case. And interestingly, this case, even though it involves Kinley and Gray, is as much about the Cooper family as it is about either of the two parties, which should imply that it often isn't enough just to look at the dockets to find the cases where your family members are parties. You might need to scan through all the papers in the county to find references to your ancestors who are further back in the story of that land and are not actually contesting it at the time, or who just are drawn into the dispute because they have information regarding some of the history of that tract. So here's the detail in the Kinley v. Gray case. After receiving a land grant in 1838, John Cooper moved out to Illinois. His brother Jesse Cooper came back to North Carolina in 1840 with what he claimed was a power of attorney to sell his brother's land. In December of 1840, he sold the granted tract to Absalom Ricks. But in June of 1841, Ricks sold the same tract to John S. Gray. In June of 1844, John Gray then sold the parcel to George W. Kinley. Kinley explained that the land was of poor quality, but he wanted it because it was next to land that he had purchased from Cooper's father, which would be a key to finding the identity of who the father of these Cooper men were. About 1844, it became widely known in the community that John Cooper had never given his brother a valid power of attorney, and that Jesse had practiced a fraud in selling his brother's land to Kinley. To Ricks. Kinley then, the current owner, allegedly, went to Gray, and Gray stated that he had a document proving that Jesse had a valid title to sell the land. Later, Kinley received a letter directly from John Cooper flatly denying that he ever gave his brother authority to sell his land and claiming that title still rested with him. Kinley presented this evidence to Gray. Since 1841, and this is what makes it all so important for these people, a small quantity of gold had been found on the property. So Kinley had begun leasing mining rights to various portions of it for 1/7 of the take. Gray assured Kinley that if he would allow him half the tolls on the gold found on the leases and rights to half the land, that he would get a good title from John Cooper out west. After all, they both stood to gain a fortune, didn't they? The gold fever gave out, however, when it became known that the rumors were unjustified and the leases ended with only 4 pennyweight of gold ever being received by Kinley. In May 1844, when John Cooper himself came back from Illinois, he again demanded that Kinley relinquish claim to the land, or he would bring an action of ejectment against him, whereupon Kinley was forced to purchase the property a second time from John Cooper. According to the warranty clause in the deed from Gray to Kinley, it was Gray's obligation to indemnify him for this expense. No word was ever given as to whether the law ever caught up with that scoundrel Jesse Cooper, or whether the Cooper brothers were in on the deal together. Very interesting case. And here is another example where the actual parties are named something. Their names are given, obviously, but the actual dispute originates many years prior with other parties ancestral to one of the individuals involved. This is the case of John McCarroll versus Stanford Cheek and William Kirkland from 1823 in Orange County. Robert Cheek the Elder obtained a grant 13th of March 1780 for about 300 acres on New Hope Creek. But in 1817, his son Richard and his son-in-law Charles Jones obtained judgments against him for about $100 and 20 pounds respectively. The sheriff sold the land belonging to Robert Cheek the Elder at public venue to John McCarroll. In 1828, William Kirkland obtained a judgment from the court against James Cheek, Robert's son.
The question was, what part of the land did Robert rightfully own, and what part was owned by two of his sons, Robert Jr. and James? Apparently, sometime in the 1790s, according to the testimony, Robert Sr. had informally divided his land between himself and two of his sons. He had actually had the dividing lines surveyed and had taken the purchase money from them, but he had never made a deed to either of them. In fact, when he pressed his sons to have a deed made, they always put him off and said that he had plenty of time to do it. And actually, it turned out he did not have plenty of time. John Cheek, another son, gave testimony in this case. Everyone was aware in the neighborhood that the division had taken place, however, and that only about 125 acres of the property was actually in the possession of the elder Robert. At the time the public sale took place for Robert Sr.'s portion to satisfy his debt, the notice described the land as that on which Robert the elder lived. When the purchaser, McCarroll, brought the deed forward for Sheriff Turner to sign, the sheriff noticed that it described the tract as 300 acres. He told McCarroll that this was not what he had sold him, that he had only sold the portion that Robert Sr. occupied, and that he must change the deed. So the sheriff changed the quantity of the land to 125 acres, but he did not change the description of the metes and bounds. Because the metes and bounds describe the entire tract with the typical phrase, 125 acres more or less, McCarroll thought he could still lay claim to all 300 acres. This case ascended all the way to the Supreme Court of North Carolina, which reversed the lower court rulings in favor of the person who purchased at the sale and demanded that the land be properly divided into three parts, with the Robert Cheek Sr. tract going to McCarroll, and the James Cheek tract being awarded to Kirkland as a purchaser at public sale. The interesting part here is that there had been a long controversy about who the father of this Cheek clan was. In fact, it had been in print for some time that his name was James Cheek Jr., but this was largely because there was neither a will nor an estate file or any recorded deed that proved any of the children. The answer was actually in a court action, and in which one party was a Cheek, and it was not one of Robert's children, but one of his grandchildren. So it paid me to look at this case. It directly related to me, even though I didn't recognize the names when I first saw it. Another kind of legal action is trespass quaere clausum fregit, which is a Latin term, which means wherefore he broke the close. We often see the term trespass in court cases without quaere clausum fregit. It's not a literal trespass onto land or property. It's just an offense that's perpetrated by one party against another, which results in damages. But when you see those Latin terms or an abbreviation, QCF, you can be sure that it has to do with a literal trespass. Quaere clausum fregit actually means wherefore he broke the close. He broke through the boundaries. He crossed a line that he shouldn't have crossed. It could involve the removal of resources from a neighboring property. It could involve hunting on another person's land without leave, as in the Gatlin case, trampling crops, coming into another's property after being warned off. It might involve the terms of a legal right-of-way. Remember that crops were supposed to be fenced in those days, not animals, as we said earlier. There are disputes related to estates and land. That might relate to the equitable division of land among heirs. Remember the distinction between size and value. Land was supposed to be divided among all the entitled heirs according to value, not according to acreage. It might relate to dower claims of widows in a third of the land for their lifetime, and to use that land not to diminish its value, not to destroy it, not to sell it outright. She was not able to do any of those things with her dower. It was there to sustain her and minor members of the family. And sometimes the heirs could get pretty snippy about how the widow was using the land, as we'll see in a moment. It might relate to additional claims on the estate by the heir, who cared for the deceased person prior to their death and incurred expenses. It might relate to lands that the widow was trying to distinguish as her own, that she owned absolutely, to the exclusion of what her husband owned, and therefore she wanted to establish her claim to that land so she could do anything she pleased with it. State-related disputes might have to do with informal means of estate division, as when a person conveyed land to an heir by informal means, was unduly influenced in the direct distribution of the estate, or when the land was placed in trust with another person who abused their trust in some way. So some examples of this taken from actual court cases. Let's take Sarah Albright's case, for example, in Guilford County. Sarah Albright's husband, Jacob, died in Guilford County in 1847, according to this court case, leaving her pretty much in the lurch. She had a large family to provide for and little experience managing the farm by herself. But about 8 years later, many of her children sued her for laying waste to the portion of the tract that was laid off as her dower, or the home tract, by removing the timber. In her reply, Sarah explained all the circumstances of her career as a sole proprietor of her farm. She explained that her first concern was to provide for her minor children, and she also had to take in a daughter or grandchild after her son-in-law died unexpectedly for about 2 years. The daughter later remarried, and the two became parties to the suit against her. Among the things she discusses is how she had to sell some of the wood to pay laborers to re-roof the house and repair a dilapidated mill on the property, which she needed to get into working order again. She was also attempting to acquire another tract because the soil of the current farm was rapidly wearing out, and the only way she could raise the cash was by selling timber. And she needed to clear a new field for a meadow in which to graze livestock, because the old field had been pretty much exhausted. Some of the wood was sold to raise money to pay the laborers involved, and some was actually used for timber and shingles. Some was used for railroad ties and firewood. So this poor woman, sharper than a serpent's tooth, hey? She was dealing with some pretty unthankful children. Besides the genealogical information we find in this case, which is in an estate file, it's not in in regular civil action papers or civil actions concerning land. It provides us with details of farm management and typical problems that women faced in raising a family alone with only lifetime rights. Of course, it also opens up a family's inability to settle its own differences privately. Now let's take another example, colorful example, from this time Guilford County civil actions concerning land. In November of 1839, Thomas Osmond Sr. applied to James Sloan and J.A. Gilmer to assist him in drawing up a deed to his youngest daughter Evelina, transferring to her all his title in 2 tracts of land, 5 enslaved people, livestock, farming equipment, and all other personal property. Now, Mr. Sloan was somewhat surprised by this and asked Mr. Osmond whether or not he should retain something in his own name, since he had a good many years yet to live. Osmond said that he was about to pack up and move to Georgia, and he had plenty of stock and cash to live on. He liked his youngest daughter best, and he had never done much for her. He wanted to make sure that she was able to go to school. He then turned to his daughter and said that it might be necessary for her to take care of him someday, just as he was taking care of her now. When the deed was signed, he then asked Mr. Sloan to secure it in his safe until he might come back to town and have it registered. Later, he came back to collect it himself, but Mr. Sloan would not surrender it unless Evelina were present. So he sent Evelina the next day with her brother Price Osmond to collect the deed, claiming that her father was ready to have it registered. Evelina saw it that day, but her brother brought it home to their father, and she has never seen it since. Now, Evelina married Albert Short a bit later, after the incident became that described happened, and it became an incident again and had to be recalled and recorded. Several other children gave testimony, including William Kirkman, a son-in-law, and his wife Eliza, and Elijah Stack and his wife Betsy. A son, Thomas Osmond Sr., is also referred to. They all claimed that besides being very drunk that day, when he made the deed at Mr. Sloane's office, so drunk, in fact, that his son had to support him on the way home, Mr. Osmond was motivated to protect his property from the debts incurred by his third wife, Huldah, who was about 35 when he was 67. There were 9 children in all, 7 by the first wife and 1 each by the next 2, and Mr. Osmond did not intend to disinherit any of the children, but merely to protect his property from his wife. So once again, we see that because the grantee, Evelina, never actually got the deed from her father, even though he signed it and collected it, that meant that it was not really her property yet. And that will come up in the way this case was decided. And then we have equity-related land issues. Now, an equity issue was heard by the Superior Court, which sat as an equity court twice a year. This is the higher court in each county, as opposed to the county or court of pleas and quarter sessions. The dockets were kept in separate volumes from the general run of Superior Court issues, but the papers are intermingled with civil actions and criminal actions concerning land. So both courts' papers are going to be intermingled, usually, in how North Carolina Archives keeps them. Equity involves a request for suspension of the common law, because strict adherence to it would result in an inequitable or unjust outcome for one of the parties. Fairness was the court's primary concern, not the letter of the law. The court would issue an injunction to suspend a legal process against an individual, usually within 4 months of its issuance, say the probate of a deed of trust or the sale of land for debt, or call into question the validity of a legal instrument as a deed made under duress or misrepresentation, and would examine the claims of the plaintiff. It would then either correct the inequity or reaffirm the instrument and allow the process to continue as before. Equity issues are considered exceptions to the rule, so the decisions are not binding as precedent for future cases. Oral promises or misrepresentation of the terms of a contract or illiteracy are very frequent issues before equity justice. Now here's a situation in which equity might come into play, taken from court records, filed in Orange County first, and then appealed to the state Supreme Court. James Reeves was a typical landless shoemaker in Orange County, but he had some advantages over the typical landless artisan. His grandfather was none other than Colonel William Macaulay of Hillsborough, one of the very early sheriffs of Orange County. In 1818, Colonel Macaulay bequeathed a couple of slaves and a house and lot in the town of Hillsborough to his grandson. But James Reeves was very much addicted to drink, and he had little capacity to manage his assets, according to testimony. His oh-so-responsible Macaulay uncles purely drip with sarcasm and disdain for him when they speak of him in their written statements. One of them, Charles Macaulay, offered to exchange title to the dwelling where Reeves was then living with his wife, children, and mother-in-law for the more valuable piece of ground in Hillsborough, but Reeves refused. Then, in 1826, a neighbor, Meredith Adams, who was distantly related to Reeves' wife, decided to step in. He discovered Reeves coming home in a drunken stupor from old John McDaniel's house after a militia muster and stopped him, bringing him to his own home with Anderson Blackwood in tow. Offering him more to drink, Adams convinced Reeves that Charles Macaulay was trying to cheat him, and that he, Adams, would offer him a much better price. He proposed a price much inferior to the actual value of the property, and James Reeves claimed that because he was so drunk, he found this deal appealing and signed. Later, his uncle Charles Macaulay saw Meredith Adams at New Hope Meeting House and realizing that his nephew would squander the purchase price, offered to take it in trust on his behalf. He then saw his nephew and realized that he didn't even remember signing the property away. Both Meredith Adams and William H. Adams, his brother, testified that Reeves later came to them pleading for a reversion of the deed and stating frankly that he thought he could get a better price from James Allison. James Jones said that Allison had agreed to pay James Reeves in grog or drink rather than because he had been incapacitated when he signed it. Charles Jones also testified that this was Reeves' motive, but character witnesses were brought in to prove that Jones was not a reliable person. Now, this is the essence of equity. Technically, Reeves signed that deed. It was recorded, and the land officially belonged to Adams, but it was obtained under unfair circumstances, and Reeves lost his case at both the county and the Superior Court level, but the Supreme Court finally agreed to revert title and compensate Reeves for any profits arising from about 2 years of Adams' possession of the land, or the lot in house in Hillsborough. So Reeves got to sell his house and lot twice. Now, this case also proves that there was some connection between James Reeves and the family of Frederick Reeves, as Frederick and his son William David were witnesses, and James is documented as traveling to their house on one of his mother-in-law's horses in order to pick up some beef. But the exact nature of their connection is still a mystery. Now, the interesting thing about this, why are all these relationships coming up in testimony? Why are we learning about family dynamics and connections? It's because the relationships affect the credibility of the testimony, so they have to be entered into the record. And that's why we're getting all these wonderful details and hints about how this family connects on both sides of the case. Now, for oral promises made that are unrecorded, we find another equity example in the case of Sarah McCollum versus Jesse Pugh. And we can find another in James Sanders versus James Neighbors and Joseph W. Connor. For misrepresentation of the value of consideration, we can look at the case of Susanna McDowell in Randolph County versus Aaron Allred in 1873. This was a case about 15 acres on Haskett's Creek, which Susanna sold for $400 Confederate dollars in April of 1865, right at the end of the war, and then when she moved to Burke County. Mr. Allred told her that this was equivalent to about $20 in gold, but because the war had just ended, it turned out to be totally worthless. So she was trying to sue to get some kind of value for that small amount of land that she owned. Among those testifying were Sally McDowell, Jessie McDowell, and Martha Ann Summers, who originally wrote her name as McDowell and then crossed it through and wrote Summers, suggesting that perhaps she had married in that time period. So we're just seeing the wealth of some of this material. Here is that court case in Guilford County, a document of complaint from the widow about how it was actually against her, and this is her reply, about how she had misused that land, but she's claiming she needed to improve it for various reasons. She needed to take care of her children, and complaining about how ungrateful they'd been for all that she'd done for her. Here's that example where James Reeves is complaining about Meredith Adams tricking him out of his lot in Hillsborough, much to the chagrin of his Macaulay uncles. So here, at the very end of our talk, let's consider what we can actually learn from studying court actions related to land. We can get an explanation for invisible land transfers when we really can't find a deed that shows how land passed from one person to another. There could have been a boundary dispute. There could have been a dispute over title. There could have been an action by which the court seized the land and sold it to cover debts and costs, court judgments, etc. We'll find the names of heirs, relations, and other parties. Obviously, from all the examples that we've gone through, we found lots of complicated family and neighborhood relationships that will lead us to look for other connections and other types of documents. So we can really break through some very difficult situations. We even find references to poor and landless people and how they became that way in these land records. They weren't always poor and landless, but they ended up losing their property in ways that are mysterious without having recourse to these court papers. We find evidence related to migrations, as with the examples of people who were delinquent in paying their taxes because they'd gone elsewhere. Lots of court testimony that is filed by affidavit from remote locations. We saw the two Cooper brothers going to the Midwest, and a dispute about whether one brother had the capacity, the power of attorney being valid from his brother to sell his land back in the old country. People sell land when they move other places, and sometimes disputes arise from that, and we learn where they went based on these documents. We could also find testimony from people who previously lived in a county and had knowledge about a particular tract of land that had nothing to do with them personally, but it could show where they went. We find a lot of personal and incidental information about where people lived and how they felt about their neighbors and what kind of character they had and whether they were addicted to drink or whether they could read or write. All those examples have come up in our rather lengthy presentation of the details of particular cases. And we get a sense of economic circumstances of our ancestors, what their intentions were toward their heirs and their heirs toward them, and all kinds of interesting aspects of their solvency, etc. So in conclusion, the use of court documents poses a challenge to the typical researcher. Their use does require some rudimentary legal knowledge, a legal dictionary at hand, knowledge of the development of the court system over time, the various jurisdictions that would apply. It requires special patience, endurance, and diligence to look through maybe years of papers for that unique document that will help to solve your own particular problem. But nowadays we have fewer excuses than we've ever had. We have digital access to a lot of this material. Civil action papers in North Carolina have been digitized. A lot of court minutes have been digitized. Not everything has been digitized, but still, we really sitting in a very unique place of advantage as compared to our predecessors in the genealogy field. You do have to learn the handwriting styles, of course, of the court officials, but the more you read their handwriting, the easier that becomes. And we have a separate presentation on handwriting. The payoff can be enormous, and to the committed genealogist, the hunt is nearly as exciting as the solution itself. So I say to you all, happy hunting, but just don't go hunting on the Needham place. Now, if you want the handout, remember to contact me at larry.cates@highpointnc.gov. And just a little preview for you. Our next presentation will come later this month or early next month, and it will be about how to approach archival materials, what to expect when you go to the archives, and particularly in North Carolina, and what you might be missing out on if you neglect that in-person research with the original materials at hand.